much as well for the invitation. I bet most of you are glad you're not me right now, having to follow all of those ladies. And also I have at least 2 former bosses in the room, Tim being another one, who was in Geneva when I arrived there, which was the first thing I was asked to talk about. What was the situation when I arrived in Geneva on posting? And could we foresee then what is happening now? And I've got a lot of former colleagues and current colleagues in the room as well. So I've got the disadvantage, I guess, of a lot of things I might have been going to say have been said in a much better way, but the advantage of therefore being a lot less, a lot more brief than what it is that I will say. So I had 3 questions to talk about in my opening remarks. The first one was, what was it like when you arrived in Geneva in the early 2000s, and could we foresee then what is happening now? That leads me to the path, the sort of unenviable task, I guess, of talking a little bit about zeroing. The second question is, what is it New Zealand's doing in this current reform process, and how are we participating in that? And the third one is very similar to what Sarah talked about, and what is it that business can do from a governmental perspective to be contributing to why it is important that we have this multilateral trading system. So in the first sense, I arrived in Geneva in early 2005, and at that time, which is a long time ago now, I think there was still a great deal of hope and belief in what the WTO could deliver. Probably we were still on that upwards trajectory of believing what we could get out of that system as a whole, as a group. And there was a lot of sort of strength and stamina and robustness, a little bit off the back of what had happened in 2004, and some successes, small successes, but nevertheless significant in terms of setting us up for a ministerial meeting at the end of 2005. That ministerial meeting at the end of 2005, the WTO has these meetings every 2 years, and Hong Kong did not go the way that most people hoped it would, and led, I think, to a questioning of the ability of the WTO to achieve another comprehensive multilateral negotiated round. So from that moment on, there started to be very serious questions about could the WTO ever deliver again in a way that it did in the Uruguay round, or at all, to the extent that by mid-2006 negotiations were suspended for a period of time. So what is not often talked about is the human factor in all of this. And given sufficient weight to what that means in a negotiating context, fatigue is real. Appetite can wane. Domestic systems can be easily distracted by perception of some other more achievable targets, and we started to see a rise of appetite in FTA negotiations. And beliefs are really tested about what it is that you're doing, why you're doing it, and can it achieve something significant. Around roughly that same time, around the mid-2000s, and significantly, I guess, around 2005 and 2007, there were 2 big cases that kicked off in the zeroing space. I am not going to attempt to explain zeroing in detail, but I will try and do it justice in a couple of sentences. In the area of dumping, which is massively controversial and is necessary from a negotiating perspective, if an exporter exports a product to another market at a price lower than what it sells at home, you may have a situation of dumping. This is not something that concerns economists, this is not something that concerns consumers, but it does concern the domestic industry into that market in which that product is being exported at a lower price. In which case, that industry might say to its government, we think we are suffering injury as a result of that action, as a result of that pricing behaviour, as a result of that dumping. Can you please do something? Zeroing is about what is then done. How that investigating authority, in New Zealand's case, MB, how those investigators in the US situation, the Ministry of Commerce, calculates what is being dumped in terms of a number, coming up with a price, coming up with a margin of dumping. The language starts to get very technical, and the lawyers have a lot of arguments about what language is appropriate to use, but ultimately you are trying to figure out what to include and exclude in that calculation. And the US has a very specific interpretation of what the anti-dumping agreement says and doesn't say on the issue of zeroing. Zeroing was extremely controversial in the Uruguay round, and was probably one of the final things, if not the final thing, to be decided in order for that entire negotiation to be concluded. Zeroing doesn't appear in the anti-dumping agreement. So for some members, that means that because language changed between what was pre-Uruguay round and after Uruguay round, you can take into account considerations for how you calculate these margins. That means you cannot zero. That's a bit of a stretch for the United States, because there is language in the anti-dumping agreement that says that you can have more than one permissible interpretation of what you can do. So this is extremely emotive for the United States. They have not forgotten it, and they have not gotten over it. And there are some, it's a highly technical area, as I hope you can appreciate from that very brief description, and that was perhaps the biggest signal of what was to come, for probably two reasons. The first reason is these cases, there were several of them. It went on for a very long time, and its origin was in a negotiating context. So prior to the Uruguay round and the outcomes that came out of the Uruguay round, most big members zeroed. They did things that ultimately the appellate body said you could not do. They disregarded certain transactions. That meant that it influenced your margin of dumping, which is what you impose at the border to provide protection for your domestic industry. So the implications are real. Depending on how you do the calculation, has an impact on your margin of dumping, which has a direct impact on how much protection you give your domestic industry, or from the other side, how much your market access is being negatively influenced by that investigation. So most members did this before the Uruguay round. After the Uruguay round, the first case in zeroing was against the EU by India, and the EU lost and changed its system. The second case was against the US in steel, but then two big cases came up, 2005, 2007 against the US, one by the EU and one by Japan. So what did that do to the system? What was happening as a whole in the system at that time? The Doha round negotiations were failing, and belief that there could be a negotiated outcome at a multilateral level was really being questioned. At the same time, the US believed that what had negotiated in the anti-dumping agreement, that there could be more than one permissible interpretation as to how you did these calculations, was being ignored and overridden by the appellate body. In addition to that, you had a competing environment between panels and the appellate body. Panels were finding, not in favour of the US, I guess, that might be going a bit far, but they were finding that the US system was not in breach of the WTO system. The appellate body was saying, no, everything you're doing is in breach of the WTO system. And they just kept going through a series of cases over about 8 years where there was a consistent difference between what the panels were finding and what the appellate body was finding. So you started to hear comments from the US. The appellate body is overstepping, it's overreaching, it's misguided, it's making findings in areas that it doesn't need to make findings in. It should be Xing judicial economy. What happens elsewhere in the system as a result of this? There are DSU negotiations. The dispute settlement understanding are the rules and procedures that govern how we argue. They're the rules that govern how the disputes are managed. What is it that you have to comply with when you're bringing disputes to the WTO? They're being negotiated to clarify what those rules really mean. The US hadn't participated a great deal, and around 2005 there started to be a lot more engagement by all members, including the US, with text-based proposals. What text-based proposals did the US come up with at that time? The title was about flexibility and member control. The kinds of things that they talked about in these proposals was partial adoption of reports, maybe to delete by mutual agreement findings in these reports, maybe to provide additional guidance to WTO adjudicative bodies concerning the nature and the task presented to them. For example, when the exercise of judicial economy would be appropriate, as well as the rules of interpretation applicable to WTO agreements. What kinds of things should you consider when interpreting what the WTO agreements actually mean? Those concerns mirror a lot of what the US is talking about, it has concerns about today, which Jennifer outlined. Things like the 90-day timeline, perhaps that's one that most members will argue about on both sides of the shop. There's a lot more complexity in the cases, they're a lot longer, it's harder to keep to these timelines. But here are a couple of other things. The AB is getting involved in facts and law. That's one of the things that the US is currently very unhappy about. However, the US is also against a remand procedure. A remand procedure is about you do not have sufficient facts on the record to make a sufficient finding to resolve the dispute, what Penny was talking about. So therefore you should go back to the panel stage to say find these facts so that we can then complete the analysis, or the panel even might be able to complete the analysis. The US doesn't think that's necessary, and yet there's a lot of argument and complexity around what the appellate body does in the facts and law area. In the Korea-Japan case that just came out, Japan was extremely unhappy at that outcome because they got overturned at the appellate body level. One of the things they were unhappy about was how facts were treated at the appeal stage, and that there was not a completion of the analysis, and they feel that their dispute has been left unresolved. What other things is the US currently unhappy about? About appellate body reports being treated as precedent. So this goes back to that whole zeroing stage. Should panels be obliged to follow what appellate bodies have done previously? Because if they are, they cannot possibly be ended up in this tension with appeal cases that have them finding in contrasting ways, where the appellate body says, no US, you can't do this, and the panel says, actually no, what they're doing is permissible. Over to dicta in appellate body reports. The United States doesn't want to see it. That's something akin to, we want to give you some guidance as to when you should be exercising judicial economy. So these gripes that the United States have are not new. But what was it that was happening at the time that the United States started talking about all these things in the DSB special session context where this negotiation was taking place? Most members, I think, at that time felt that it was more dangerous to the system to listen too carefully to those concerns. Are we going to interfere with the independence of what the appellate body says and does, and how these reports are adopted? How does it change the balance of where members feel they are being served by the system? Because probably it's the bigger members that would negotiate what didn't end up in a report, and smaller members would never know that once it was adopted, but somehow these bigger members would have had insight to appellate body thinking. Too much negotiation on what should be an independent judicial process. So most people at that time felt the bigger fear was giving too much attention and too much meaningful engagement to what the US was complaining about. And now these years later, here we are. You cannot ignore these concerns by a big member when it is that emotive and that with that much history about what the zeroing issue was prior to the Uruguay roundup outcomes and what was happening after, between panels and the appeal stage, what's going on in the Secretariat. That's often something that doesn't have a lot, I guess, of vision outside of the inside workings of the system. Personalities inside the Secretariat really matter. Who's the director of a division? Who's been put on a panel? Why have they been put on a panel? Panels are composed from indicative lists and from knowledge of what people have inside the Secretariat as to who would make a good panelist in a particular case. It's not a permanent body of panelists. So there's political manoeuvring in that. So all of those things play into how the system operates, how people perceive what the threat is, and how the US is reacting to that. I think also, in addition to that, there was a concern that if you gave the US too much manoeuvring at that time, probably you wouldn't be able to contain it very well. There is a lot of concern about unilateral actions as well, and I think Penny's touched on both on that in the sense of what's going on now in the security system. How did we get from there to where we are now? What does it mean now? How are we seeing the behaviour now? And the security exception is a really interesting one. There is a security exception that exists in the GATT. It is there for members to use if they believe that there is a threat to their security in 3 specific instances. And that had never been utilised before, and now the United States is turning to that to try and utilise that. And what does that mean in the broader picture? And the findings that come out of the dispute settlement system on that, of which there has already been one, what will that do to how the system is perceived by a big and important player? And will it continue to mean that the system overall is threatened? So So if I move on to the second point, and that is what's New Zealand doing in the midst of all of this? Well, I once heard a long time ago, early on in my involvement in all things trade, a scenario akin to a playground about how you consider WTO members. So you have the big players on the school playground, right? The ones that really matter. You kind of want to be their friends, but they can be a little bit bullyish sometimes. The EU, the US, probably China these days too. Then you've got the cool kids, the biker kids, you know, the ones that are you kind of want to hang out with, but they're just a bit too cool for school. Maybe that's your Caribbeans, maybe Pakistan as well. And then you have your kids that are studious, they do their homework, they show up, they're ready to contribute. They are there and want the system to operate. New Zealand, Australia, maybe Canada. And that's the role that New Zealand is taking in these discussions. Our job really is to defend and strengthen the system for all of the reasons that you've already heard. It's worth fighting for. Without it, we're not better off. We want to avoid a return to those power-based trading relationships because New Zealand just can't operate on a level playing field if that's the scenario and that's the context. So what is currently going on? Well, we have involvement from our ambassador in a significant way. He's the chair of the DSB. There are proposals on the table in the form of guidelines. So these guidelines, of which there are at least 4 proposals from a variety of members, attempt to address the US concerns. The US is not engaging. The US is in listening mode. In addition to that, what we also have are some other things going on in the system that collectively gives rise to, I guess, a broader discussion and perhaps broader concern. What's going on in the space of a developing country issue? This has always been a very heated and emotive, again, discussion inside the WTO. China has always been of the very strong view that you cannot distinguish between developing countries. But increasingly, a lot of members believe that it is necessary to, and in fact it is just obvious that you would. But how does that apply to obligations? How does it apply to what you're entitled to? How does it apply to market access? And that's a more complicated question, and the US has come right out and put it in the centre of the table by putting down a proposal that's probably not got appetite, certainly from the membership as a whole, and is quite divisive as a discussion. So then you rely on some other members to come in behind that with more nuanced proposals, of which Norway is another one of those kids that does all their homework, and New Zealand likes to be friends with Norway on those kinds of issues. I think probably I'll just start to wrap up there because you're probably sick of hearing us speak and want to come up with your questions. The final thing I would mention is in relation to what can business do to help support and strengthen the rules-based system. I think Sarah's covered that really well. I would say that there is a need for a meaningful dialogue between government and between business. That's nothing new to any of you. But I think that dialogue also needs to be set in the context of what is government policy. What is the government doing right now, and how is it that business can be useful and meaningful to that discussion to hold up those values of predictability and security of a system that is useful for all of us. So that's about understanding what we can currently do, what our limits are, and what our aspirations are. Without the knowledge, your ability to influence is severely curtailed. So it's about being sufficiently informed so that you can contribute and influence that debate at the government level, both sort of at the ministerial level, but also at that government to government level.